What evidence do you need to get an order of protection in New York? People seeking orders of protection must show that a family offense occurred in New York and provide evidence that persuades the judge that abuse is more likely than not. This guide outlines the types of proof courts accept and explains the process for filing in Manhattan. Knowing how to compile police reports, medical records, and electronic communications can help build a stronger case and ensure immediate safety. Under New York's Family Court Act Section 812, you must show that the respondent fits within the family or household member categories and committed a qualifying family offense such as disorderly conduct, harassment, menacing, assault, stalking, or strangulation. The standard of proof in Manhattan Family Court is a preponderance of the evidence, meaning you must convince the judge that it is more likely than not that the abuse occurred. This civil standard is lower than the criminal standard of beyond a reasonable doubt, but as the petitioner you carry the burden of proof throughout the case. To obtain an order of protection in New York, you need evidence that is competent, material, and relevant, such as sworn affidavits detailing incidents with specific dates, times, and locations. Witness statements and police reports can show a pattern of repeated incidents, but the weight given to these documents depends on evidence rules at the hearing. Medical records, photos, and security camera footage provide objective proof and are persuasive to judges. Electronic communications like text messages, emails, social media posts, and voicemails demonstrate harassment or threats, particularly when they show a pattern of abusive behavior over time. While affidavits are sworn statements, they are still considered out-of-court statements and cannot substitute for live testimony. Your lawyer or attorney can present admissible evidence and object to hearsay. An order of protection is a court order that prohibits someone from harming or contacting you, and it can be full, blocking all contact, or limited, allowing contact but forbidding threats or violence. You can request an order through family court against a current or former spouse, someone with whom you share a child, a relative by blood or marriage, or anyone with whom you have had an intimate relationship. In Manhattan, petitions are filed at the Family Court on Lafayette Street or the New York County Supreme Court on Center Street, depending on whether the matter is a family law or civil case. After you file, a judge may hold an ex parte hearing if you face immediate danger, issuing a temporary order that lasts until the next court date and provides quick protection. The judge will later hold a full hearing where both parties present evidence. Final orders in family court typically last up to 2 years, though orders may extend to 5 years for aggravating circumstances or violations of prior orders. Criminal court orders are issued in criminal cases and can stay in effect during proceedings and probation. Both family and criminal orders are equally enforceable statewide, and violating any order of protection is a crime. Manhattan residents can seek assistance from the Manhattan Family Justice Center and Safe Horizon, which offer case management, counseling, and help preparing petitions, and the National Domestic Violence Hotline provides confidential support. Evidence rules ensure fairness, and consulting an experienced attorney helps you understand what documentation will help your case, and a dedicated lawyer can guide you through each step. The law office of Richard Roman Shum, Esq., is a Manhattan law firm committed to helping victims secure protection orders and navigate the legal process, and our law firm values clear communication and steady advocacy and offers consultations to discuss your case. The law office of Richard Roman Shum, Esq. can be reached at 646-259-3416 and is located at 20 Clinton Street, FRNT 5D, New York, 10002, United States.